The man at the front of the room did not look up when she walked in. That was the first thing anyone noticed. Not the way Lorraine Dupree moved, quietly, deliberately, the way people move when they have spent 40 years making sure they take up exactly the amount of space they are entitled to and not 1 inch more. Not the leather portfolio under her arm or the small gold pin on her lapel that said, if you knew what it meant, that she had spent 3 decades working in federal infrastructure law before most of the people in that room had passed the bar. None of that. What people noticed was that Dr. Hessler did not look up. He was writing something on the whiteboard, a case citation, something from the Fourth Circuit, 2019. He wrote with the marker the way some men write. Like the marker belonged to him, like the room belonged to him, like the particular quality of silence that follows when a senior partner walks in, was something he had simply not registered. Lorraine Dupree took the only open seat, which was in the 3rd row, between a young associate named Britta and a man she had never met who smelled faintly of coffee and anxiety. She set her portfolio on the table. She folded her hands. She waited. The seminar was called Advanced Infrastructure Liability in Federal Contracting. It was hosted 3 times a year by Alderton Haynes, one of the 6 largest law firms in Washington, D.C. The people in the room were not students. They were attorneys, engineers, policy advisors, 2 sitting judges who had come purely out of professional curiosity. Lorraine was the only black woman in the room. She had stopped noticing that the way you stop noticing the hum of a refrigerator, it was always there. It did not require her attention. What required her attention was the whiteboard. Dr. Hessler had finished writing and was now speaking. His name was Jeffrey Hessler, and he held an endowed chair at Georgetown, and he said his own name the way people say the names of places they went to college, with a particular flatness that is actually a form of announcement. He was explaining a methodology, a framework he had published, he said, in 2021 in the Yale Law Review. In a paper that had since been cited 43 times, he said 43 with the same flatness. Everything he said was flat in exactly this way. It was the flatness of a man who has never once considered that a room might not be listening. Lorraine was listening. She was listening so carefully that she did not notice she had uncapped her pen until it was already in her hand. The methodology was for calculating federal liability exposure in infrastructure contracts that cross state lines. A niche area, but one that had become significantly less niche in the past 4 years, after a series of highway collapses and a dam failure in Kentucky that had moved the entire field several inches to the left of where it had been. Hessler had been one of the first scholars to publish on the new landscape. He had, by all accounts, built the framework that half the room was now using, which was why, when Lorraine looked at the 3rd variable in his formula, she went very still. Not the way people go still when they are surprised. The way people go still when they already know something and are simply confirming it. She wrote a number in the margin of her notepad, then another number beside it. Then she drew a small arrow between them and put a question mark at the end. Hessler was moving on. He was explaining how the framework accounted for variance in state-level enforcement timelines. He was using the word robust. He said it twice. Lorraine was not listening to the word robust. She was working through the calculation in her head, and what she found, each time she worked through it, was the same thing. The 3rd variable was wrong. Not wrong in a minor way. Not wrong in the way that produces a small error that washes out in the final calculation. Wrong in the way that, if you were using this framework to advise a federal contractor on their liability exposure, you would tell them they were exposed to something in the range of 12 to 18% less risk than they actually were, which meant that somewhere right now there were contractors operating under this framework, and Hessler had said it had been cited 43 times, which meant there were lawyers advising clients under this framework who were walking into federal projects underprepared for what they would owe if something went wrong. Lorraine set down her pen. She picked it up again. She looked at the formula on the board, and then at the number in her margin, and then back at the board. She raised her hand. Hessler did not look at her. He was in the middle of a sentence. He finished the sentence. He started another one. Lorraine kept her hand up. A woman 2 seats to her right shifted slightly in her chair. The young associate, named Britta, looked at Lorraine's hand, and then at Hessler, and then at her own notepad. The man with the coffee smell stopped moving entirely. Hessler turned to write something else on the whiteboard, and registered in his peripheral vision the hand. He glanced at her. "I'll take questions at the end," he said, and turned back to the board. Lorraine lowered her hand. She looked at her notepad. She looked at the number she had written in the margin. She thought about the contractors. She thought about what it meant to advise someone incorrectly on federal liability. Not theoretically, not academically, but in the specific and practical sense that someone would eventually stand in front of a judge and be told they owed more than they had been told they would owe. And there would be a framework with 43 citations. That was why. She raised her hand again. This time, Hessler did not glance at her. He continued speaking. The man with the coffee smell turned to look at Lorraine in a way that was not unkind, but was also not helpful. One of the sitting judges, the one from the 8th Circuit, whose name was Harlan Foss, and who had a long, careful face and the habit of watching rooms without appearing to, noticed the exchange and said nothing. Lorraine waited until Hessler paused to click to the next slide. "The third variable," she said. She did not say, "Excuse me." She did not say sorry to interrupt. She said the third variable, the way you say the name of a street you live on, as though it is already established between you that this is what you are talking about. Hessler stopped. He turned around. She said, "You're using the 2019 state enforcement baseline as a fixed input. But after the Kentucky ruling in March of 2022, that baseline was superseded in 9 states. If those states are included in a cross-boundary project, the third variable isn't stable. It shifts with each new state that updates its enforcement standard, which means your liability range isn't 12 to 18% below federal exposure. It's closer to 26. No one moved. Hessler looked at her for a moment. Then he said, "The Kentucky ruling was a procedural decision. It doesn't affect the substantive standard. It affected how the 6th Circuit interpreted the substantive standard," Lorraine said, "which is what matters when you're in litigation." Hessler's expression changed in a way that was very small and very legible. He said, "I'm aware of my own publication." "I'm sure you are," Lorraine said. "I'm also aware of it. I'm saying that the third variable, as written, produces an underestimate in multi-state projects where post-2022 enforcement data is applicable." Someone in the back of the room cleared their throat. Hessler said, "We can discuss this at the end," and he turned back to the whiteboard. Lorraine wrote the number 26 in her margin. She underlined it once. She did not raise her hand again. At the break, she stood by the window with her portfolio and a cup of bad coffee. Britta came to stand beside her and said, in a low voice, "That was something." Lorraine said he should update the variable. Britta said, "You've done federal infrastructure work?" And Lorraine said, 31 years, and Britta said, "Oh," in a tone that suggested she had not previously understood what she was looking at. Hessler did not approach her during the break. He spoke to a cluster of men near the coffee station, and once, briefly, looked across the room in her direction and looked away. When the seminar resumed, he did not revisit the variable. He moved forward. He covered the next 4 slides. He said robust 2 more times. At the end, he opened the floor for questions, and 2 men asked questions about enforcement timelines in the Pacific Northwest, and 1 woman asked about pending federal guidance, and Hessler answered all of them with the same flat confidence he had used all morning. Lorraine did not ask a question. She had already asked it. It had simply not been answered. Afterward, the room broke apart the way seminar rooms do, people collecting their things, exchanging cards, moving toward the door in the loose configuration of people who have been in the same room for 3 hours and are now being released. Lorraine was capping her pen when she felt someone standing near her and looked up to find the judge, Harlan Foss. He had a legal pad under his arm and a look on his face that she had seen before, on other careful faces, usually right before they said something they had been thinking about for longer than they were going to let on. He said, "The Kentucky ruling. You said 6th Circuit." "Dot!" "Yes," she said. Hessler's framework was developed for Fourth Circuit jurisdictions, primarily it was, and it's being applied in Sixth Circuit jurisdictions, which is the problem. Foss looked at his legal pad. He said, "Have you written this up anywhere?" "Not yet. If you do," he said, "I'd read it." He handed her a card and walked toward the door. Lorraine looked at the card. She put it in her portfolio. She picked up her coffee, found that it had gone cold, set it down, and walked out of the building into the October air. She did not feel triumphant. She felt the way she always felt after these moments, which was tired in a very specific way. Not exhausted, not defeated, but tired the way a person gets tired when they have been asked, again, to be twice as precise and half as audible as the man standing next to them. She had started her career in 1991 at a federal public defender's office in Baltimore. She had moved into infrastructure law in 1998 when a case she was working on had intersected with a highway procurement dispute, and she had found, to her own surprise, that she was good at it. Better than good. She understood the machinery of how federal money moved and what happened to it when something went wrong, and she had a particular ability for finding the place where a calculation departed from what the law actually required. Her colleagues called it her instinct. Lorraine always thought this was a strange word for it. It was not instinct. It was arithmetic. It was the willingness to do the arithmetic all the way to the end instead of stopping where it got uncomfortable. She had spent 31 years being told, in various ways, that she was stopping in the wrong place, that her reading was too narrow, that her calculation was sound, but the application was off, that she was technically correct, but practically irrelevant. She had spent 31 years being correct anyway. What happened next happened because of Harlan Foss, and also because of a second-year associate at Alderton Haynes, whose name was Davis Gould, and who had been sitting in the back row during the seminar and had done something that Lorraine did not know about until 6 weeks later, which was that he had gone back to his desk that afternoon and pulled up Hessler's 2021 paper and spent 4 hours going through the calculations in Section 3, and then he had sent an email to 3 partners at the firm with the subject line that said, simply, "There may be an issue with the Hessler framework." The 3 partners had different reactions. The first said forward this to compliance. The second did not respond. The third, whose name was Maureen Achterberg, and who had been practicing federal infrastructure law for 25 years and had built a significant portion of the firm's practice on work that cited Hessler's framework, read the email twice, then walked to her window, then walked back, then replied, "Get me the name of the woman in the 3rd row." It took Maureen Achterberg 11 days to find Lorraine Dupree. This was not because Lorraine was hard to find. She had her own practice. She had a website. She had published in the Federal Contracts Law Journal twice and in a Georgetown policy review once, and she had filed 15 amicus briefs in the past decade, several of them on exactly the kind of multi-state liability questions that Hessler's framework addressed. She was, by any reasonable measure, findable. It took 11 days because no one at the seminar had written down her name. Not the registration list. She had registered under her firm's name, Dupree Law Group, which was a small firm, which was why no one had immediately connected it. Not the young associate who had noticed the exchange and said, "That was something." Not Hessler, who had not asked for her name and had apparently decided not to wonder about it. What Maureen Achterberg found, when she finally found her, was a woman who had been doing exactly the kind of work the firm needed done and had simply never appeared on the firm's radar because Alderton Haynes had a very specific idea of what expertise looked like, and Lorraine Dupree had not, at any point in her career, made herself look like it. They had lunch at a restaurant in Georgetown that Lorraine had eaten at once before, years ago, for a different meeting about a different thing. Maureen Achterberg was a direct woman, she said. "You were right about the variable." She said it the way Lorraine had said the 3rd variable, as though this had already been established between them. Lorraine appreciated this. She said, "I know." Maureen said, "We have 16 active matters that used Hessler's framework in the liability analysis. We need someone to go through them," Lorraine said. How many of them involve cross-boundary projects with post-2022 state enforcement updates? Maureen looked at her notepad. At least 9. Lorraine said, "Then you have a problem." Maureen said, "Yes, which is why I'm sitting here." What Lorraine found over the next 3 months, working through the 16 matters, was not catastrophic and was not minor. It was the kind of problem that does not produce headlines, but produces very expensive quiet settlements and a significant amount of revised documentation, and, in 2 cases, conversations with federal contracting officers that were not pleasant for anyone involved. She found that 7 of the 9 cross-boundary matters had used the third variable in exactly the way she had identified, as a fixed input, stable across state lines, when it was not stable, had not been stable since March 2022, and the attorneys who had used it had done so in good faith because they were trusting a framework that 43 citations said was reliable. She corrected each one. She wrote a memo, 19 pages, that laid out the issue, the applicable case law, the corrected calculation, and a recommendation for how firms should audit their existing infrastructure liability work going forward. Maureen Ochterberg circulated the memo internally. Then she asked Lorraine if she would allow the firm to distribute it more broadly to the other firms in the field, to the federal contracting officers, to the policy organizations that track this area. Lorraine thought about this for a day. Then she said yes. The memo circulated. It reached, among others, the editor of the Federal Infrastructure Law Review, who emailed Lorraine and asked if she would be willing to expand it into an article. It reached the law school at Georgetown, where a professor in the federal contracts program forwarded it to his colleagues with a note that said, essentially, "Read this." It reached Hessler's department chair at Georgetown, who called Hessler. That conversation was not documented. What came after it was, in February, 8 months after the seminar, Hessler published a correction to his 2021 paper. The correction ran to 6 pages. It cited, in a footnote on page 3, a forthcoming article in the Federal Infrastructure Law Review. The author was listed as L. Dupree. The article came out in April. Its title was careful and technical and would not have meant anything to anyone who did not already understand the field. To the people in the field, it meant quite a lot. It said, clearly and completely, and with the kind of arithmetic that goes all the way to the end, that the framework that had been cited 43 times had contained a calculation error that produced systematic underestimates of federal liability exposure in multi-state infrastructure projects, and that the error had been identifiable since March 2022, and that the corrected framework was this, specifically, here, with these numbers, for these reasons. Judge Harlan Foss read it on a Tuesday afternoon. He sent Lorraine a short email that said only, "I told you I'd read it." Lorraine read the email. She was sitting at her desk in her office, which was a small office in a building in Silver Spring that she had rented for 22 years. On the wall behind her desk, there were 3 framed documents: her law degree, her bar admission, and a letter from a federal contracting officer in 2009 that said, in formal language, that a brief she had filed had prevented an incorrect interpretation of a procurement clause from becoming precedent. She had never told anyone about the letter. It was just there, on the wall, because she thought it was important to remember what the work was actually for. She replied to Foss's email. She thanked him. She closed her laptop. She thought about the man who had not looked up when she walked in, who had not taken her question when she raised her hand, who had turned back to the whiteboard and said, "I am aware of my own publication," and she thought about how he had said 43, and she thought about the number in her margin, and she thought about what it means to be precise in a room that is not listening. It means you do it anyway. She put on her coat. She turned off the light. She walked out of the building into the March air, which was cold and clean and indifferent in the way that March always is, and she went home, and the work remained.